Hello, I'm Christina Davis, the Director of the Program on U.S.-Japan Relations. I'm very glad to welcome you today to our panel on the Ghosn controversy in Japanese corporate governance. Ghosn is the executive who was once heralded as a hero in Japan for helping to restore Nissan from near bankruptcy in 1999, as he led an international alliance between the French car maker Renault and Nissan. Indeed, it's now 20 years since he was first appointed as Nissan's CEO. But of course, he now stands accused of stealing from the company with allegations of significant financial misconduct. After his 2018 arrest in Tokyo, he made a dramatic escape from house arrest in December 2019 to flee Japanese custody to Lebanon, where he now resides. 2 Americans who were accused of assisting his escape have just been extradited from the United States to Japan as the saga continues to attract international attention. Indeed, there will be a 6-episode TV miniseries production using this fascinating episode to explore the human drama and the broader political business context that sets the scene for the rise and fall of Carlos Ghosn. Today, as the Program on U.S.-Japan Relations, we are going to look at the case from the perspective of thinking about corporate governance in Japan. There have been many reforms, including a set of 2015 reforms that corporate boards of Japanese listed companies should have at least 2 independent directors. In addition, the widely discussed cross-shareholdings that embed corporate relationships in Japan, sometimes extolled as the strength of patient capitalism, sometimes pilloried as a weakness and source of zombie corporate structures. But these have all been changing under pressures of globalization and market demands. How does corporate governance and business practice in Japan succeed or fail to induce accountability over executive compensation and strategic decision-making? To answer these questions, we are very fortunate to have 2 leading experts on Japanese corporate law. Today, we will be joined by Professor Curtis Milhaupt, the William Baxter Visa International Professor of Law at Stanford University. He is the author of many articles in law journals, as well as several prominent books. He is the co-author of Economic Organization and Corporate Governance in Japan, the Impact of Formal and Informal Rules. He has also authored books on law and capitalism and corporate crises, which make him especially adept to consider the problem we are discussing today. And recently, he has a new book out and several articles that are turning his attention to looking at Chinese state capitalism. His Oxford book in 2016 addresses Regulating the Visible Hand, the institutional implications of Chinese state capitalism. We are also joined today by Mark Ramseyer, Mitsubishi Professor of Japanese Legal Studies at Harvard Law School. He is a leading expert of studying Japanese politics with his path-breaking book in 1993 on Japan's political marketplace, co-authored with Francis Rosenbluth. He has also written extensively on Japanese corporations, the topic of our panel today. His 2006 book is called The Fable of the Keiretsu: Urban Legends of the Japanese Economy. He has also written the 2015 University of Chicago book, Second Best Justice: The Virtues of Japanese Private Law. We're very glad he could make time today because he's teaching a corporate law course at Harvard Law School at 1 o'clock, and so he will have to leave our session a little bit early. But now I'd like to introduce our next seminar for next week and then come back to some Zoom etiquette and our speakers, who will each have 15 minutes to talk, and we'll then open up to Q&A. Our event this Thursday is the commemoration of 10 years since Japan's 2/11 disasters, where we will reflect on the anniversary of this tragic event with experts from around the area and the moderator, Andrew Gordon. For today's event, I would like to remind you of our Zoom etiquette. All attendees will have their image muted and their Their image and microphone muted. And you may submit your questions to Q&A, and I will moderate the questions after our speakers conclude. We ask that you refrain from any unauthorized video. Let's begin. And we'll start with Professor Milhaupt.
Okay, thank you very much, Christina. Good afternoon, everyone. I'm really delighted to be here. Thank you for having me. It's a pleasure also to be with Mark, to talk about this really fascinating episode. I guess I'm not surprised to hear that it's being made into a TV episode. It has all the makings of pretty good drama. So I'm going to talk about the corporate governance angle to this crisis, and I think the major outlines of Ghosn's rise and fall are pretty well known. I'll go rather quickly over those points and try to focus on what I see as some of the more interesting structural, corporate governance, even cultural aspects to this saga. So, very quickly, I think the background here is pretty well known, and Christina already mentioned that Renault was brought in 1999 to turn around a Nissan that was on the verge of bankruptcy. And what's interesting is the form of the alliance here. I kind of come to think of this as a sort of Japanese style keiretsu, but one that has really interesting features. This is kind of a Franco-Japanese keiretsu under the ultimate control of the French government, which makes Nissan a really interesting entity from a corporate governance perspective. So it's kind of lopsided across share ownership relationship, with Renault taking 37 and now 43% of Nissan. Nissan, given its dire straits at the time, got 15% of Renault with no voting rights. And at least reportedly, the French government insisted on bringing Mr. Ghosn in to run this alliance. And as is well known, Ghosn very quickly returned Nissan to profitability by taking steps that at the time were unheard of, and still today in Japan are very unusual. So I think he reduced headcount by about 20,000 workers. He fairly dramatically streamlined the ringi process of this hierarchical decision-making and communication structure in Japanese companies. And he introduced performance-based compensation for key executives, which again, at the time, I think maybe Sony was experimenting with performance-based compensation, but certainly it was not widespread. And perhaps we can talk about this. I think there's still some kind of resistance or reluctance to have performance-based compensation on the part of Japanese executives. So, in a very short order, Ghosn returns Nissan to profitability, and as we all know, he's hailed as a hero, despite having violated, or maybe because he violated these Japanese norms, to considerable success. He increases his power by becoming CEO of both Nissan and Renault over the next couple of years. Now, from corporate governance perspective, I think what's interesting, the result of this unusual alliance is that you had some corporate governance characteristics of Nissan that are very familiar to any observer of Japanese corporate governance, and others that were quite distinctive, or that seemed to be a reflection of this unusual alliance. So Nissan had at the time a traditional Kanseiyaku board structure. This is the dual board structure, which is a kind of diluted form of the German dual board structure, in which you have a board of directors, which actually manages the firm, and a board of statutory audit with a very limited role. Their role is to ensure that the board of directors is complying with the law. Personally, I think the Kanseiyaku system has never really worked very well. I think the Kanseiyaku board is kind of second-class citizens vis-a-vis the board of directors. And it's hard to see that it was actually functioning in this case, in which you had, the CEO basically hiding half of his compensation for a period of years. The board, in kind of an egregious, I think, derogation of its role, delegated to Ghosn the power to set his own compensation. So there are no committees on this board, as is typical, at least was typical, of a Kanseiyaku board. It did have 3 outside directors, someone from Renault, a retired race driver, and someone from the ministry. So this was kind of typical, I suppose. Well, maybe not typical even to have 3 outside directors, but typical in the sense that they didn't seem to be very effective in challenging or pushing back against Ghosn's authority in any way. Ghosn was in his position for almost 2 decades. Certainly with the support of Renault and ultimately the French government. So the French government owned 15% of Renault, but under a French law of tenure voting rights, a shareholder in France who owns shares or holds shares for more than 2 years is entitled to double votes on those shares, unless the shareholders vote to move back to a 1 share, 1 vote regime. So France has 30% of the votes of Renault. And so ultimately, seems to me they're in control of this whole enterprise. And the French government seems very covetous of these double votes because I think it was 2015, Renault's management actually had put forward a resolution for the AGM to go back to the 1 share, 1 vote. And the French government in response actually increased its shareholding in Renault in order to be able to vote this down. So I think we can infer that they care quite a bit about remaining in control of Renault. Ghosn, as is well known, basically ran the firm with the help of a small circle of trusted lieutenants, including Greg Kelly, who's on trial as we speak in Tokyo for these events. And in 2018, Nissan actually disclosed, hey, we're not following best practices in a couple of key areas. Succession planning, we don't really have one. And Ghosn is nominating each director and deciding their compensation. Again, egregious breach of standard corporate governance norms. And then, of course, the alliance adds Mitsubishi Motors in 2016. And there's tension that's going on here. The French government is clearly hoping for consolidation of the alliance and a merger between Renault and Nissan, which is a backstory of Ghosn's perspective on this whole scandal is that it was a palace coup because he favored this alliance, which was resisted by Nissan. So the scandal derives ultimately from corporate governance, and there's an interesting story here. Of course, Ghosn is highly paid by Japanese standards, not so high by the U.S. auto industry standards. But ultimately, the trigger of this crisis is a change in the disclosure rules in Japan. The DPJ came into power in 2009. For reasons that seem a little bit odd. They focus on executive compensation. Perhaps it's a pro-union stance. Of course, the global financial crisis had hit, and there was a lot of discussion of U.S. executive compensation. I don't think anyone was arguing that Japanese executives were too highly paid. But in any event, the disclosure rule is changed. Prior to this, the board's total compensation had to be disclosed to shareholders and approved. But now a company would have to disclose the compensation of all individual directors who are paid over 100 million yen, or about $1 million, and they need to disclose the components of that compensation. So I actually did, with a co-author, Rob Jackson, we looked at the first year of disclosure under this regime. We found, not surprisingly, Carlos Ghosn was the most highly paid executive at this time. He was paid just under, I think, $9 million. What we learned is that actually was only half of his compensation, because the other half was hidden. And so, interestingly, apparently Ghosn was concerned that if the French government learned how much he was actually being paid, they would be unhappy and would try to have him fired. And so he engages in a scheme with Kelly to essentially defer or hide half of his compensation. And the SEC settlement actually quantified this. So his remaining compensation of $90 million is not disclosed. And they pushed some of it into his retirement pay of $50 million, not publicly disclosed. And they used apparently a variety of secret contracts, backdating of incentive plans and the like to obfuscate and hide this compensation. Ghosn is also accused of making personal use of Nissan's so-called CEO reserve fund, Apparently, he had the company cover some of his investment losses by funneling funds to a friendly auto dealer in the Middle East, and then those funds apparently made their way back to him. So this eventually leads to the criminal charges against him, which Mark is going to talk about, and a settlement with the SEC. Not that it matters very much now, since Ghosn is a fugitive, but he was prohibited from serving as a director of a U.S. public company for 10 years. The rest, I think, is quite well known. He steps down as CEO in 2010. There's a whistleblower that alleges wrongdoing. Internal investigation is launched, and both Ghosn and Kelly are arrested when they come back to Japan for a board meeting. Leading to this, very fascinating criminal justice aspect of this scandal, which Mark is going to talk about. So after this all happens, Nissan launches an internal investigation. Really fascinating report is released after that, which blames consolidation of authority in Ghosn, which is true, but that there are obviously corporate governance failures that allowed Ghosn to amass so much power within the firm. And I've listed here, the sweeping set of reforms that the report recommended, and most of those actually, I think, were adopted by Nissan. So today, Nissan has changed its board structure. It has a so-called company with 3 committees of audit, compensation, and nomination, each of which have a majority of independent directors. It now has 7 independent directors, which is high by Japanese standards, even today, notwithstanding a pretty steady increase in the percentage of boards that have independent directors today. And it has a lead independent director and outside director meetings. So, they've cleaned up some of the obvious defects in their governance structure. I guess time will tell how effective those will be. There's still a lot of pressure and question marks around this alliance. So I'll just end here with a couple of thoughts. What are, interesting points to me are that, and Christina actually alluded to this. So in one decade, Ghosn is heralded as a hero in Japan for massively violating standard Japanese norms about not laying off employees, not being overly compensated and the like, and really becomes a hero in corporate Japan for that. But then in the next decade, he's brought down by these norms. Ultimately, the decision to try to hide half of his compensation was a reflection of the fact that he was worried about what disclosure of his full compensation would mean in Japan and for this relationship ultimately with the French government. There's no question that better corporate governance would have likely prevented this particular scandal. You had essentially a supine board with, which had allowed the CEO to set his own compensation. But I wonder, given the unique nature of this alliance, as what I referred to before as a kind of Franco-Japanese keiretsu under the ultimate control of the French government, run by a US-style imperial CEO. That's a pretty interesting combination. And it seemed to me that some kind of crash may have been inevitable given the dynamics and personalities at play in that. So I'll stop here and turn the floor over to Mark.
Shall I start, Christina?
Yes, please go ahead. Thank you.
Okay, great. Thank you. This is it's a real honor to be on the panel with Curtis. We somewhat arbitrarily, or entirely arbitrarily, decided to split this into talking about corporate law and talking about criminal law. And Curtis very kindly agreed to talk about the corporate part. So let me just add a few comments about how we might think about the criminal aspect of what's going on. And with the caveat that Curtis knows the details of this case much better than I do. So let me keep my comments a little more general than Curtis did. And the basic point is that criminal procedure involves making trade-offs. And Japan and the US have made different trade-offs. It's not obvious to me that one is necessarily better than the other. These are two very humane and very wealthy, well-ordered democracies. And it's important that one keep this in mind. I think it's also important that one avoid our standard response in the United States, which is to think of this as a sport or as a game. And as a game where what we're trying to do is to keep this as a level playing field between the prosecutor and the defendant. And that's not what's going on. What we've got in the criminal process is that there's been a crime committed. And we're trying to ascertain whether this is somebody who warrants being punished by society. And there's no reason to think of this as a sport. The trade-off is between the risk of punishing somebody who maybe didn't do this and the risk of increasing crime. If there's anything that's very sort of endlessly empirically shown, it's that punishment deters crime. And punishment is about the probability of being punished and about the magnitude of the sanctions. It's these two. And what we have in the US is a system that bends over very far to try to make sure that we don't punish somebody who just might happen to be innocent. And we need to understand that when we do this, we're reducing the probability of punishment, and that increases the profitability of crime, and there's going to be more crime. There'll be more people who we don't know, who are not identified, who are going to suffer crime if we, in fact, we bend over too far, or the extent to which one does bend over. Japan also works very hard to prevent the punishment of somebody who's didn't commit the crime, but does not bend over quite as far as the US. And so it's that difference that's at stake here. Just understand that just simply trying to avoid, if at all possible, punishing somebody who is innocent is not costless because errors there result in increased levels of crime. And this is very basic social science. Okay, now, one should also understand, though, that the magnitude of the punishment depends on the specific sanctions that are being imposed. And Japan imposes much lower sanctions than in the US, holding constant the type of crime that's being committed. The punishment that somebody convicted receives in Japan is a lot less than it is here. So when one's thinking about the sort of procedures that go to the determination of whether somebody should be subject to criminal sanctions, understand that the criminal sanctions themselves are lower in Japan than they are here. Okay, so where's the problem? Which of these do we have a problem? Look at Japan and look at the US. You know, I look at Japan and I see a pretty safe, low crime environment. I don't see a whole lot of problems there. And whatever the source of the problem in the United States is, it's clear that we have a problem. We have an unusually high level of violent crime in the US for a country that's as wealthy as we are. So whatever the problems may be in Japan, you know, understand, guys, we have problems here. Now, in terms of what applies to the Carlos Ghosn case, let me talk about three things. One is it true that everybody who gets prosecuted in Japan gets convicted? Okay, so that second, what's this about this incredibly long detention for this fellow? And the second is, how come he doesn't get to have his attorney there when he's being interrogated? Okay, so let me talk about these 3 points. people complain. They complain that the conviction rate in Japan is 99+%. Right? It is. It really is that high. Okay? Now, what is it in the US? Well, this is when you start getting into problems, trying to figure out what it is you're trying to compare with what. Because in the US, we have plea bargains. You don't have plea bargains in Japan until recently, and only for a very small subset of crimes in Japan. But you do have confessions, okay? So these appear to be trials, but the defendant confesses because the defendant knows that the judge will give a lower sentence if he or she confesses, and the judge knows that the defendant knows that the judge knows this, and so forth. So one has to deal with things of that sort. Okay? Now, it's also the case that in the US, we have a federal system and 50 separate state systems. So trying to figure out what in the world could possibly be the overall average in the US is really hard. Let's suppose that a reasonable guess, which I think is the case for the federal system, would be 85% conviction rate, okay? Now, think of that, okay? Is that what you want? And here's the problem, which is 99% a problem? Well, it might be, but it might not be. But we know that an 85% conviction rate is a serious problem, because it either means that a substantial cohort of guilty people are going free, which is not good if what we're trying to do is deter crime. The other possibility is that a substantial number of innocent people are being prosecuted, which is a serious crime. Being prosecuted criminally is a killer for your reputation. The financial consequences are enormous. It's not just that we want to avoid convicting innocent people. We should be trying to avoid prosecuting innocent people. And something in the US is going wrong, okay? The last thing about this to keep in mind is that in Japan, only a relatively small minority of cases sent to the prosecutor's office result in prosecution. So there's a huge number, a large fraction of cases that never get prosecuted. And a reasonable guess, it seems to me, would that overworked prosecutors are picking the slam dunk guilty ones and only handling those. The others get processed through by having the accused make compensation to the victims and working through a whole host of things like that. Keep all of this in mind when you're thinking about the 99% rate. Second point. So one of the I found this amusing about the Carlos Ghosn case, which is that this seems to be an example of what in Japanese is called bekken koryu, bekken taiho, which is, it used to be relatively common for violent crimes. So you've got a guy, you're the cops, you think he killed somebody. But you don't have, you're pretty sure, but you don't have real evidence. But you do have evidence that he beat up somebody. So what do? You arrest him for beating him up. And that gives you, I think it was 23 days to interrogate him. You don't interrogate him about the beating up. You interrogate him about the murder, right? So you spend that time interrogating him about the murder. You gather the evidence. The 23 days are up. You turn around and arrest him for the murder. Right? So you use a pretextual arrest to be able to interrogate him for something that you really care about. Now, the Japanese Supreme Court never made clear that this was unconstitutional, but it sort of stinks, and everybody knows that it stinks, and law professors didn't like it. And until this Carlos Ghosn case, my friends in Japan were telling me, yeah, we don't do that anymore, okay? So what happens here? Carlos Ghosn gets arrested for what? For executive compensation disclosure that sounds questionable because did he really have a right to this or didn't he? It sounded funny to me because in the US, we do arrest people and put them in prison for securities violations. It's very rare that happens in Japan. It's not zero, but disclosure violations, they don't, in in the vast majority of cases, result in physical custody and prison time and so forth. But they're doing it, right? Like, what are they doing? Well, lo and behold, what happens? It turns out that they think he was stealing from the company and millions of dollars. So this is really a case about theft. And the executive compensation was a case of one of these: arrest him on one thing, interrogate him about the other until you have the evidence. So apparently it still happens. Last point. Japan and the US, we both have constitutional rights to have an attorney. In the United States, that's interpreted to mean that anyone interrogated has a right to have the attorney present whenever the interrogation occurs. In Japan, it's interpreted to mean that anyone arrested has a right to consult with an attorney from time to time, but not to have the attorney present. Okay, we can have debates about which one of these makes sense, which one would be better, and so forth. Just let me say, it's not obvious to me that one trumps the other. I could make cases for both of these, and I suspect most of the people in the audience could too. So you keep those in mind while we're talking about all of this. So thank you very much.
Thank you, Mark and Curtis, for a really interesting setup of the issues that are presented by Carlos Ghosn controversy and thinking more broadly about corporate governance and criminal justice in Japan. I'd like to turn open to questions from our audience, and I will also moderate the questions and read a shortened version sometimes. So we can start by thinking broadly, what do you feel is changed by the fact that Carlos Ghosn was this unusual foreign executive? Because some of the attention to this issue has been whether he was going to face fair process in the Japanese court system. And so last February, the Japanese Minister of Justice, Masako Mori, wrote an op-ed to the Nikkei defending Japan's criminal justice is committed to equal treatment of foreign nationals and Japanese citizens with fair, neutral judgments. And yet Carlos Ghosn had said he would not stand a fair chance. And so this is another dimension where this issue presents a question about globalization of the Japanese economy, as more and more Japanese firms do have international shareholders and international executives. Do you feel that corporate governance reforms introducing independent board members will continue to have international members of their board? And on the criminal justice side, would you agree that the justice system is set up well to give equal and fair justice to foreign nationals and citizens? That's just my own opening question, and I'm hoping that our audience will start to write in questions, and I'll turn to our audience next.
Mark, take it away. You get the first, I went first to the presentation, so you get the first crack at the question.
Okay. So do I think Carlos Ghosn would get a fair trial in Japan? Yeah, I think so. Do I know so? No. Could I demonstrate this? No. It's just an instinct. Knowing, as Curtis and I both know, a lot of highly educated Japanese lawyers and so forth. So I guess the one thing that I would add, and I'm guessing Curtis doesn't disagree with this. Clearly, there was a bad case of corporate governance here. Things went really bad. The question would be, how much of this is a function of having had a traditional Japanese corporate governance system, which I'm a little more puzzled by, if only because, for example, most Japanese traditionally governed corporations don't have this scandal. And there are plenty of American companies with an American-style corporate governance system that do have this scandal. And so, I mean, it's an interesting question, which one gives rise to more sorts of scandals. But I confess I'm just puzzled by this.
I would say so a couple of things on the is this unfair treatment of a foreigner? One interesting point is that Saikawa, Ghosn's successor, apparently also hid some portion of his compensation. He had to step down, but he wasn't arrested. So maybe that suggests some sort of unfair treatment. But I actually think it goes to support Mark's point, which is that maybe Ghosn's arrest had very little to do with hiding his compensation and more to do with embezzlement. And maybe there was no evidence, this is all speculation, but maybe there was no evidence that Saikawa had engaged in that kind of behavior. So maybe the more lenient treatment of him relates more to Mark's point than to some kind of obvious unfairness toward foreigners. On the corporate governance side, I certainly agree with Mark that Japan has no monopoly on corporate governance scandals by any means. So it's hard to identify scandals with a particular number of independent directors or board structure, et cetera. Every corporate governance system seems to fall apart in some companies, in some cases. One thing that's interesting, I had a point on my slide which I didn't get to, so I'm happy to have the chance to talk about now, which is I think this was a US style scandal in the sense that it seemed to be for one guy's personal enrichment, as opposed to what I think of as a more typical Japanese corporate governance scandal, which is like an Olympus style scandal, where at least arguably you could say that the cover-up was about, I don't know, not having a shameful mistake exposed to the public or something like that. And so there's accounting fraud in both cases, but one's for personal enrichment. I think that's a typical US case versus a cover-up to kind of, I don't know, quote unquote, for the company's benefit. And maybe that takes us back to different employment structures and the like.
Very interesting. And I think that actually turns to the question from Alizia Kuchekova, who wants to ask you to evaluate Japan's corporate governance code, thinking in terms of these multiple audiences. How does Japan's corporate governance code structure to achieve transparent, timely, decisive decision-making with attention to the needs of both shareholders and customers, employees, and communities? And so as you think about a range of stakeholders for Japanese companies and the balance of which stakeholders' interests are respected, how would you evaluate the Japanese corporate governance code as favoring one over the other? And especially she asks about the question of sustainable growth. So we could also think if we were to turn to shifting values towards sustainable development or attention to other issues.
Well, that could be the topic of about five additional webinars, I think. I mean, just very briefly, I would say, I guess I'm an outlier in the sense that I'm not overly impressed by the corporate governance code and the stewardship code. I mean, I think they're fine, and I know they're important parts of Abenomics. If you read them, they're pretty anodyne. They don't say anything that's really very surprising. I think have they had an impact? Yes, because they have kind of focused people's minds on, hey, we probably should have more independent directors, or we should think about why we're holding the shares of our business affiliates. What is the strategy behind that, et cetera. So these are all things that a corporation should be doing. I don't know that you really needed a code in order to carry that out. It's all voluntary anyway. It's comply or explain. But I don't want to be dismissive of it, but I don't think there's anything magical in the code. I think that Japanese firms historically, as everyone on this call I'm sure knows, have placed a higher priority on non-shareholder interests than do say US or UK firms. I think that has shifted. I think the Abenomics reforms did shift the attention of management to more toward financial returns and paying more attention to shareholders. But certainly ESG, environment, society, governance is a buzzword in Japan as it is everywhere else, and stewardship, the idea is to be engaged for the long run. So there's a lot of different things going on in Japan, as I think there are in corporate governance around the world. How it's going to play out or who's actually going to benefit, I think, is an open question. The one Professor Miyajima has what I'm aware of is the best empirical study of the results of Abenomics thus far. And maybe I'm overgeneralizing, but I think the results show that basically there have been higher payouts to shareholders, but management has not become more innovative or risk-taking, and so it seems like shareholders have benefited. It's not clear that workers or others have benefited from those reforms. So it's a very complicated picture, and I've just picked out a couple of pieces of that.
Great, thank you.
Let me add a point, which is that let's be realistic, folks, about what we can expect from the board. A board is, it might be 9 people, it might be 21 people, but they're folks they're elected by the shareholders, and that's the shareholders are the ones who pick them. Yeah, they're nominated by the board themselves and so forth, but these are people who are chosen by the board, by the shareholders. Shareholders want to make money. Okay, that's what they're there for. And when one starts to add all sorts of other, all these other concerns, I think it's not going to work, right? It's not like the way this is set up is that they're simply not going to be catering to all of these other constituencies. And in fact, what strikes me as much more likely is that lazy directors who are not doing their job and are not making a lot of money because they're spending too much time just being nice to each other or playing golf or whatever, are going to say when pressed, no, the reason we didn't make so much money is because we were looking out for stakeholder interests and we were looking out for community welfare and all of this other stuff. So when you complicate the metric by which to evaluate people, you make the disingenuous fudging a lot easier. And so thank you.
Excellent. We have a question from Takatoshi Ito of Columbia University that pushes to consider the comparison of the French government role. He says, you've mentioned that the French government had ultimate control over Nissan, so that any problems at Nissan, corporate governance, high compensation, lack of attention by Ghosn, who he notes did not spend much time at Nissan lately, are the French problem as well as the Japanese problem. And he asks, we have to bring in the French way of corporate governance in our discussion, so that maybe lack of corporate governance was actually a convenient way for the French government to deal with the problem.
Well, I think that's a really interesting point. I wish I knew more about this angle on the case to know what the French government, what they were thinking, the extent to which they were involved or aware of what was happening at Nissan and with Ghosn. They clearly, at least tolerated Ghosn for many years. So I agree that that this is a very important aspect of the case. I just don't know much about this particular angle, and maybe others do, but I agree it's worth investigating, and it's not entirely a Nissan issue, because unusually by Japanese standards, this is a company that had a controlling shareholder, which happened to be the French government. So I wish I knew more about the dynamics at work there, but I just don't. I think it's really worth investigating.
One of our audience participants, Deborah Daly, notes that it was an international leadership issue, reminding us that the French government was strongly backing Renault's influence, as well as the severity of the complaint being brought. So hopefully she and others will be continuing to look into these issues on both sides. Which also, as we think about corporate governance and the comparison of, to some extent, this was French government ties to Renault, we also can bring in the comparison to Chinese state capitalism, where, Curtis, you are a leading expert. And we do have a question from Joyman Lee asking if there's any convergence between Asian corporate government structures in comparing how Japan and China's corporations operate. As someone who's studied both, do you have any comments on that question?
Yeah, interesting question. The Chinese system is so distinctive because of the role of the Communist Party in corporate governance. I don't think there's really any analog to that. Imagine if, Japanese, well, I don't want to extend the analogy too far, but just imagine if the LDP had a committee in every public Japanese company, and it was a little bit murky as to what the role of that LDP committee was. And in some firms, that committee seemed to be pushing Abe or Suga's, political policies into the firm level, and going to Mark's point, kind of muddying the waters of the objective of the firm, so that it was not only carrying out business for profit, but was also trying to advance the policies of the LDP. That's a kind of rough analog to what Chinese state-owned enterprises do. And so I think it's really distinctive. Now, I think there are these conflicting trends or different currents going on in every corporate governance system. Again, kind of picking up on things that Mark said, I think every corporate governance system today is talking about ESG factors, sustainability, non-shareholder interests, and the like. The extent to which that's taken seriously in around the world, I think, varies dramatically. It's not even clear, to Mark's point, that this is necessarily a positive development. My own personal view is that corporations are being asked to do a lot of things today that actually the governments should be doing, and that if we had a stronger social safety net, we would not have to rely on or ask corporations to perform these social functions. So I don't see convergence necessarily between China and Japan on any direct level, but I think the various currents that are in play around the world are quite similar in any system today. Certainly, the stewardship movement, which started in the UK, has taken off and has spread around the world. Many Asian countries, including Japan, of course, have a stewardship code. But if you look deeply into, and on one level you say, well, there's convergence around this idea of stewardship. But actually, if you look carefully at the codes themselves and how they're being implemented, they're performing very different roles. So the UK stewardship code was designed in response to the global financial crisis and the fear that institutional investors in the UK were too short-term in their mindset, and that they were putting pressure on companies to be too short-term oriented. That was the impetus for the UK stewardship code. In Japan, the stewardship code, I think, had quite a different function, which was to try to invigorate institutional investor monitoring and engagement with firms, to try to, again, kind of change Japanese mindset to think more about their investors. So those are two very different reasons for adopting the code, and there are other examples as well of different motivations. So even though there's a lot of predictions always about convergence, I really don't see it happening other than at a relatively superficial level.
I want to turn to a question for Mark, because I know he has to leave. If you can, before you jump off our call, David Johnson has asked, Professor Ramseyer says that the first premise in the Ghosn case is there was a crime, but that this is not the formal premise of the Japanese criminal legal system. The premise is there may have been a crime, which is different. And criminal suspects in Japan have a right to remain silent, but they also have a legal duty to endure questioning. And so he's focused on this issue about the interrogation, which was said to be over 500 hours. And what is the propriety of having such a long interrogation practice?
If listeners think that the interrogation was too long, that's fine. I mean, I think we all have our instincts about whether something is too long, not enough, whether more should be allowed, and so forth. I have no objection to people complaining about that. The only thing I want people to understand is that there's a trade-off here, and that the harder you make it to convict somebody who has committed a crime, the more other people will perceive it to be potentially profitable to engage in crime. And we need to understand this. We need to understand that limiting the ability of police and prosecutors is not a costless endeavor. So, I mean, presumably the prosecutors thought there was some return to it. That's why they spent all this time at it. Should we allow this? Well, you know, people make these trade-offs. And my point is simply that Japan and the US are both well-ordered democratic regimes, and they have come to different outcomes here. And this has been really fun. I mean, I've learned enormous amounts from Curtis. I expected to learn a lot from Curtis, and I most certainly did. So thank you. And I apologize to everybody, but I have to go teach American corporate law. So
thank you, Mark, for joining us on a busy day. And I'd like to turn now, Curtis, back to corporate governance questions. We have two who are interested in thinking about the Carlos Ghosn affair in the context of also the Toshiba scandal. Terry Porte points out an observation that there's this distinction between stealing from a company for one's own benefit and for the benefit of the company. Look at Toshiba. Cooking the book for over 10 years, Nishimuro, the longstanding president, was never attacked. He went on to preside over Japan Post. And we have a similar question asked about whether you see the Ghosn affair and the Olympus as the Japan-style one, and would the Toshiba scandal be closer to the Ghosn US-style governance scandal or closer to the Olympus Japanese-style scandal?
Mm-hmm. Well, yeah, I mean, these are great points, and they kind of point back to the, you know, my earlier comment. I do think that there are different political economies, different corporate governance systems seem to give rise to somewhat different scandals. They all seem to break down at times, but I think I think there's a link to executive compensation here. So in the United States, where so much of an executive's compensation is tied to performance and stock price, there's tremendous incentive at some level to manipulate the books to boost the stock price and therefore one's personal compensation. That has, you know, typically not been the motivation in Japan. There isn't nearly as much performance-based compensation in Japan, and I think the imperative is to keep the company going. And again, I think this goes back to the employment structures where you have, of course, this is changing, but you have a relatively illiquid labor market. You have a relatively illiquid market for high-level corporate managers in Japan. And so, you know, maybe, you know, Mr. Porte's comment, the executive actually being able to move on seems to me somewhat unusual in that you don't have much of a liquid labor market for white collar workers in Japan. And so I think there was a real imperative to keep the company going and to cover up mistakes. And so I think that that's really what distinguishes the two systems in terms of the impetus for many of their corporate governance scandals.
Do you think that the Ghosn affair will lead to changes beyond Nissan in how companies structure their boards and encourage accountability over compensation?
Well, one thing that's happened recently, which is quite interesting, is that even companies that have not adopted the three committee system board structure have created committees of the board on a voluntary basis. I think that's an interesting movement. I think that it's an attempt to deal with this issue. Apparently, the company with three committees has never been popular in Japan. It's been around, it's coming up on 20 years now, and still only something like 2% of eligible Japanese companies have adopted that structure. The reason one typically hears is that the Japanese president is loath to give up the right to pick his successor and doesn't want to have an independent nomination committee. functioning. So this was a way, to keep the more traditional board structure, but to set up committees to try to give somewhat more structure to nomination and compensation, I think is an interesting development. It seems structurally still somewhat weak because these are voluntary committees, and you don't have the formal backing of the recommendation of the committee that you would have in a formal committee structure. But I think this is an interesting development to watch. I also think that executive compensation in Japan is very fascinating, and performance-based pay is interesting. If you talk, and some of the programs actually have been put on by Harvard and Columbia as well, where they're talking to investors in the Japanese market and activists, and they still are somewhat astonished that Japanese executives are very reluctant or hesitant to accept performance-based compensation. So there still seems to be something of a norm against performance-based pay, stock options, and the like in Japan. Of course, it's changing, but I think that's a key difference between the United States and Japan in terms of the corporate governance structures.
And in order to consider whether foreign executives would want to be an executive for Japanese companies, one issue is, will Japanese companies, in order to entice the best talent of the world, have to change their corporate compensation practices? But the other is a question raised by Susan Farr about this issue of, will a corporate executive who is not a Japanese national be treated equally? And so she raises this question that you might have inequality within a legal system, that, as Mark mentioned, the US system is bending over backwards to protect the innocent, but among those in the United States, the Black Lives Matter movement has tried to highlight that they do not feel there's such bending over to protect the innocent in that particular case. And so what about the Japanese system? Does it also have differential justice? And is that going to be a case that would deter top executives or workers from wanting to launch a career in Japan?
Well, one thing we know in terms of unequal treatment, foreign executives are treated differently than Japanese executives in terms of compensation. So the study that I referenced earlier that I did with the co-author showed that foreign executives are more highly paid than Japanese executives are, holding other things constant, and they're also paid more in terms of performance-based compensation. And so, actually, we found a link between companies that had adopted the U.S. style committee structure and greater use of performance-based compensation. So it could be that those companies were trying to signal to foreign investors, we have a familiar board structure, we have familiar executive compensation structures. So there is unequal treatment in that level. And I think Japanese, on the compensation front, I think Japanese executives tend to be, only in the domestic Japanese market, whereas if you think of a Ghosn, he's obviously an outlier even in that extent, but foreign executives operate in a more global market, I think, where their compensation is set more by global standards than by Japanese standards. On the criminal justice front, I'm certainly not a criminal law expert. I could certainly see that a foreign executive might look at the Ghosn case and say, wow, that looks scary to me. And he seemed to have gotten roughed up by the Japanese criminal justice system. I don't want to take that chance. I don't know. I guess you could also point to the Olympus case where I'm forgetting his name now, but the British CEO who was essentially a whistleblower, and then he also seemed to get roughed up in Japan, not so much by the criminal justice system, but in the media and the like. So, I could certainly see those cases having an effect on a foreign executive who's thinking about working in Japan. But I'm sure there are many other considerations as well. So my personal view is that I doubt that for most people, those would be, front of mind in terms of a decision not to take a position, an otherwise attractive position in Japan. But others may be a better place to answer that.
Right. And watching this panel, they will be learning more about what they would face should they take the dive into such an adventure. Two last short questions about the strategies of the firm, and then wanting to close because we're coming to the end of our time. One of our audience asks about why the alliance with Mitsubishi, and how does an allied company reflect on scandal affecting Nissan? And another remark from Takatoshi Ito about the French government role, thinking about why were the French pushing Renault not to shut a factory in France, even as they were able to do so in part because Nissan was closing factories that helped to increase its profit revenues.
Mm-hmm.
Do you have any comments on the broader alliance?
Yeah, I mean, these are great questions. I hate to end on questions that I really can't speak to, but you know, I think one would need a much keener understanding of the global auto industry than I have to answer the question about exactly what Renault and Nissan thought they were getting from the Mitsubishi alliance. I think, you know, there's obviously pressure on electronic vehicle development, and the auto industry has become, you know, incredibly even more competitive. And I think the pressure on innovation and global scale, I'm sure we're behind, at least partly behind, extending the alliance. But beyond that, I really can't speak to that. And same goes for again, very fascinating question about the French government's angle and role in all of this. And I hope that others on the call who are listening, who are intrigued by this, will dig into this, because I think frankly, it's part of this episode that has not been, at least that I'm aware of, has not been deeply studied or reported on. So I think that's really, really interesting for follow-up.
Thank you so very much for giving us a broad range of perspectives on corporate governance. And it was also quite interesting to hear thoughts about the Japanese justice system in a comparative perspective about different trade-offs that we all face. We've also received questions on other issues, and I apologize that I've not been able to raise them. They have high merit and should be addressed in another forum that would be able to fully give attention to all of these very serious issues that are being raised. On this important event, I just want to thank you, Professor Milhaupt, and in absentia, thank Professor Ramseyer for joining us to talk about the Ghosn scandal.
Thanks very much for having me.